I just wanted to see who the first person to talk was going to be. All right, gentlemen, we are live. While everyone trickles into this wonderful live stream, we will do the standard introduction. We will talk about standard introduction stuff. Let's start with Uncivil Law on the bottom. Kurt, while everyone trickles in, for those of you who don't know Kurt already, you want to introduce yourself?
Yes, my name is Kurt. I also go by Blackleaf, and the stars at night are big and bright, deep in the heart of Texas. The prairie sky is wide and high, deep in the heart of Texas. So, cheers to you.
Not knowing exactly what that was, and that was not planned. Nate, do you know what that poem was?
It's a song about Texas, and it's an allusion to the fact I just moved to Texas.
And how
so I could sing it.
Thus
the stars at night are big and bright, deep in the heart of Texas. The prairie sky is wide and high, deep in the heart of Texas.
That's just something you kind of got to know, though. That's something you just got to know.
But I did it more of a
monotone, a Canadian here,
Shatner style, But we'll sing it for you too.
Okay, well, I'm going to go look that up after this particular stream. I have a song to look up. Nate, who are you? Well, we all know who you are, but where are you? Tell everybody.
My name is Nate, and I'm a YouTube lawyer like these other guys here. Channel's Nate Borady, and I do a lot of this kind of the same things. Actually, we all kind of do the same thing. We read cases, we give our opinions. So, I'm just like another flavor of Viva and Blackleaf, more or less.
So the cool thing is that the longer YouTube goes on now, the more YouTube lawyers there are, and I like to list them so everybody should know who's out there. We've got the three of us. There is Steve. Every time I say Jared Leto, but that's a totally different person. You got Steve Leto. You've got Leonard French, Ian Corzine,
Nick
Riketa. Who else do we have? We got Legal Eagle. We've got
Christian Hall does some libertarian stuff.
Okay, I don't know who that is. Christian Hall.
Christina
Hall. Okay, cool. There's
what about the copper guy?
Oh no, Ian Corzine.
Yeah.
Ian Corzine
or Hogelaw.
Hogue's Law. Yeah.
You've got Hogue's Law. You've got J House Vlogs.
Mm-hmm.
Whoever we're forgetting is going to be angry. I think we've gotten pretty much everybody.
No disrespect to other people.
Yeah,
we'll get.
There's a lot of lawyers who are on here because I watch a lot of their stuff too. So not as active as we are, but there are some.
Yeah, it's an amazing it's a growing niche on YouTube, and it's phenomenal, and it's great to have this sort of community that we can. Community. I just said it in a non-ironic way, but we can throw together a Friday night live stream and talk about stuff that was going on.
And you guys were recently broing it out in person in New York. I wasn't invited. I was very sad about that. I just want to note.
Nate,
that's why you're singing in the heart of Texas. Don't you in Texas?
I could have come for you.
Well, I will go to Texas and we'll meet up and we'll go fishing, Kurt. But I met up with Nate in New York. Nate, for anybody who doesn't really appreciate it, is much taller than me. I'm short, so it's
yeah. Most of the men in my family. It's funny because for my family, I'm actually short. Most of the men in my family are taller than me. I'm 5'10", so
5'10", and I'm 5'5" on a good day. Okay, so now the theme or the structure or the topics for the night. We're gonna do Roger Stone. Obviously, talk about some questions that I have. Questions that I had, and we'll get into also Akilah, obviously, versus Carl Benjamin, aka Sargon of Akkad. Now, actually, one thing I didn't mention or we didn't go over in starting this, everybody who's watching probably knows already, but first things first, share the link, tweet it out on social media because YouTube has apparently been like 12 to 14 hours late in some notifications from what I've been told. So send it out and let people trickle in over the next 1 minute. Kurt, what's your area of expertise for law?
Patent law, intellectual property.
Okay, and that's going to come in good for Akilah, obviously. Nate, what's your specialty?
I'm criminal law, but specifically in New York, and I do some civil stuff, but more criminal.
Okay, and that is going to come in useful for Roger Stone.
And what is your specialty, Viva?
Right now, it's I'd say jack of all trades, master of none. No, I did commercial litigation in Quebec, so I have the most. I was going to say useless niche of practice, but I have the most secluded niche of practice because Quebec civil law is the only civil law province in Canada. I think it's civil law like Louisiana and I want to say
Just Louisiana.
not California. And not Mississippi, so just Louisiana. Okay.
Just Louisiana.
So
I didn't know that. I thought all of Canada was civil law, so you corrected me.
No. In fact, all of Canada is common law, except for the province of Quebec, which is civil law. So it is crazy because like I'm only certified.
The French, man, the French.
Well, it's the Napoleon influence. Like our code used to be the Napoleonic code up until until 100 years ago. Then it became it was reformed and it became the Civil Code of Quebec. So we've got the Civil Code. Ontario, the other provinces have common law. There's federal law, which applies in Quebec and throughout Canada, but I'm certified to practice civil law in Quebec. And if I have to practice federal, I can do that outside of the province. Good. 6.5 minutes, 341 people. I can't see the thumbs up and I can see the comments. So that's good enough. Okay. You want to start with the Roger Stone? You want to get like the juicy one out of the way before we get into this stuff. I think Roger Stone might solicit or elicit a lot of questions from the crowd.
All right. Maybe we should go over the facts, like what happened with the facts.
Who wants to do it? Because we haven't planned any of this in advance. I don't want to put anyone on the spot. I can say them as best I understand them, unless somebody wants to do it.
Nate, it's all you.
I'm vaguely familiar with it, so
okay. So as far as I understand it now, the issue. Okay, so Roger Stone. I did the video on it. He was indicted on 7 charges, 5 charges of lying to Congress, 1 charge of obstruction of proceedings, and 1 charge of witness tampering. And I did a couple of vlogs on this, and I did a live stream with Robert Barnes. We got into it a little bit, like without getting into the substance of the lies, because it doesn't really matter at the end of the day, although it matters to a lot. Apparently, Roger Stone lied about things that were untrue. He didn't lie about things that were true to conceal them. So apparently, like the punchline of the whole story is he lied about having connections with Julian Assange that he didn't actually have. Something along those lines. But bottom line, apparently in the investigation, he was found to have lied 5 times under oath. His witness tampering consisted of text messages alluding to the fact that he was going to take some other witness's dog. If he testified, the details are murky, but bottom line, he was indicted on those 7 charges, found guilty on those 7 charges by one Judge Amy Berman Jackson. Judge Amy Berman Jackson is also the same judge that had tried Paul Manafort and convicted Paul Manafort previously. And some of the facts that are going to come up that are going to be very similar between the 2 cases is that in both cases, there were gag orders issued. In both cases, there were accusations that the gag orders were violated, et cetera, et cetera. In Roger Stone's particular case, he stood trial before a jury, was found guilty on 7 charges. Was it before or after sentencing? So this is where there's some disagreement on the facts, or at least some confusion. The prosecutors were recommending 9 years in jail, and apparently this is where there's some disagreement. It's either they had misrepresented to Attorney General Barr that they were going to go for 4 years and then recommended 9 years, or there was some sort of implicit agreement that they were going to go for 4 years, but instead went for 9 years. They recommended 9 years. Then the Department of Justice got involved and said overrode their recommendation to say not 9 years. We're not going to allow that. And then what ended up happening is they ended up withdrawing as prosecutors in the file out of protest before sentencing. Then one of the 12 jury members, went on to CNN to stand in solidarity with the 4 prosecutors who withdrew from the file. In so doing, doxed herself, publicly identified herself, and within short order, I think Mike Cernovich would be glad that I mention it. Mike Cernovich, who is familiar with the methods of the internet for what has been done to him in the past, rightly or wrongly, depending on your perspective, knows now to do it as like a strategy of war. And apparently pulled out like tweets and social media posts from this particular jury member who was also the jury forewoman, which were very incriminating and demonstrated patent bias. That happens. Then there's a whole hoopla about whether or not this was a fair trial, whether or not the gag order issued by the judge was sort of directly, indirectly, deliberately, inadvertently intended to shield these jury members from public scrutiny to disclose their social media imprints. If I miss any super chats or anything, let me know, people, and I'll get to them. I'm sort of reading the comments as we do this. So that whole hoopla happens. Roger Stone files a motion for a new trial. And then you have the sentencing. In the interim, Roger Stone is sentenced to 4 years. And after he's sentenced to 4 years, he still has his pending motion for a new trial. He makes a motion for judicial disqualification, which is a motion for recusal, depending on the jurisdiction, which Judge Jackson, because as it is always the judge adjudicates on their own motion to disqualify, says no. There's no bias. There's nothing that warrants recusal. This motion just sounds like an excuse to put in the court record a motion that conflates the words judge and bias for, publicity purposes. That is, unless someone's going to tell me I got something wrong, I think that's the 30,000 foot overview. If I may,
that was better than I could have done.
Yeah,
that was good. That was detailed.
I don't think I missed anything. Nate and Kurt, in your entire careers as attorneys, Nate, I don't know how, Kurt, I don't know how much litigation active litigation you've done. Have either of you ever made a motion to disqualify or a motion for recusal?
my work is transactional, so no.
Okay.
No, never. I have not done a motion for recusal.
Okay, so just to illustrate, I mean, I have never made a motion for recusal, although at one point some of the comments the judge made to me, comedic jokes about his experience with my father, might have warranted it because my dad's been a litigator in Montreal for 47 years now, give or take. I had one, and so
family business.
Say it again.
This is the family business.
Yeah, no. So the joke was it was my learning experience because don't ask judges rhetorical questions. I was petitioning the court for extrajudicial termination of a commercial lease. And there's a clause in the lease that says you can you're entitled to extrajudicial termination without a court order by virtue of the lease. And so I was asking the judge to enforce it because I don't need to go to trial because we have this clause in a lease. And he says, I'm not enforcing that on an injunction, go to trial. And then I said, if I have to go to trial every time to enforce an extrajudicial termination clause, what's the point in having it? To which the judge says, I don't know, go ask your father. All right. On that note, so the joke I made in the video was that the only judges who are going to grant such a motion by being petitioned by one of the parties, the only ones who are going to grant it are going to be the ones who are going to raise it of their own volition in the first place because they will perceive the conflict. They don't even need to be told that there is a conflict there. So,
or one of the attorneys has dirt on the judge, and so they're basically bowing to the implied extortion.
Well,
so
that is it. If you go into that realm, yes, well, that can never be proven nor disproven. I would just say, in the ordinary run of things, when you say to a judge, you should recuse yourself because you're biased, the motion to recuse is always presented before the judge who adjudicates on it, setting aside an appeal. And you have to wonder, if they are in fact biased, are they going to say, I am biased and I should really get out of the file, and I'm going to grant the motion in favor of whom I am biased against? It's totally paradoxical.
No, well, actually, it's something interesting that you just said, because I know I'm thinking from the O.J. Simpson case when there was an issue that came up between Lance Ito and his wife, and didn't they have a system where another judge would actually make the call whether he should recuse himself or not? It's not him; it was another judge.
So that's it.
Do you know what I'm talking about? Uncivil law, because I know some states have a system where another judge would actually make the call.
Yeah. That's going way far back. I can't remember that far back, but I vaguely recall what you're talking about. So yeah.
I don't in Quebec, I'm with certainty it's always the judge who, barring an appeal, it's the judge whom you're requesting to be recused or recuse themselves that adjudicates on it. And if they say no and you want to go to appeal, one of the decisions that Roger Stone's attorneys cited in their motion was from an appellate court that granted the recusal of the judge who I suspect initially refuse it in the Microsoft decision, but I mean, I didn't make that decision. So it's sort of like crazy paradoxical, because you have to rely on the judgment of the judge whom you're accusing of being biased against you to recuse themselves in a file against you. Then the flip side is, they always say, like, better the devil you know than the devil you don't, and you're just going to get another judge who, by and large, will not be any less biased depending on the political circumstances. So that
it might be tough. Even let's say even in the California system, when you have another judge do it, it might be tough for that judge to make that call, especially them being colleagues and stuff. You know what I mean?
Yeah. No, it's very interesting. We got.
I mean, I personally think that there's a pretty decent chance at this point that the judge might order a new trial because of the blatant bias of this foreperson. As I understand it, the foreperson was in court testifying 3 days ago, with counsel from both people available to argue whether or not there should be a new trial or not. And, with the amount of bias, it's hard to believe that she completely honestly answered the questionnaire, completely honestly answered the voir dire, and that no one was able to detect this level of bias. So I'd imagine there's got to be something to disqualify.
I don't know. I've at the DA's office, I've seen the crazy juror get on the jury before. You know what I'm saying? I've seen it happen. It's like, how the hell did this guy make it past everything?
But you knew they were. But did you know they were crazy?
You had your suspicions, but the craziness was subsided until they were sitting down. And you're like, oh my God, juror number 5 is insane. I've just seen it happen in real time. Like, oh my God, we know.
So the interesting thing, by the way, I did a live stream with Robert Barnes where we talked about the Roger Stone, the process, and the jury selection process, at least in the federal, from what he said in the federal criminal court, was they don't have weeks to do this. They have like a morning to select their 12 jury members from 60 with their automatic strikes. The process did not permit for like thorough vetting, period. One of the issues was that the gag order that the judge had put into effect effectively barred anybody from talking about the jury members publicly, so that there could be no public scrutiny to do this vetting that may have ought to have been done before. But that's the issue. The motion for new trial is one thing. The motion for recusal is one thing. The motion for the new trial is another thing. Yeah. And if there's a new trial, it's still going to be Judge Jackson that is the judge.
I'm half surprised that Trump hasn't just nipped the whole thing in the bud and just issued the pardon. At this
just
point,
call it a day.
I mean, he even has cause. Not that he needs to have cause, but he even has cause of, well, look, this entire thing was tainted, which is a righteous reason for an executive to issue a pardon. The process was tainted, the court won't do anything about it, so I will. So it's like, well, I'm half surprised he hasn't done that yet.
Well, so as soon as you scream new trial, I think you have it, because that's this juror, I think, is so bad that there's no way this judge can win. If this judge rules that the juror should be thrown out or rules for a new trial, there's no way that Trump cannot pardon this Roger Stone. I don't see why Trump would even allow Roger Stone to go through a second trial, because he's already got the reason now. Okay, so one question about that, Nate, because you do the prosecution. One question about the delays in the second trial. What was it Stone lied about? If you go to the first vlog I did on Roger Stone, there was a screenshot of the 5 lies, and they were basically about having had contact with Julian Assange and interactions with Julian Assange. That's what the lies were about. They were literally blowhard lies, not lies to conceal facts, rather lies to lie about non-facts. But Nate, if there's a second trial, like say you have to be tried and there's the ticking clock, right? In criminal prosecution, you have a certain amount of time within which to be prosecuted. It's the speedy clock. Yeah, so we call it a speedy clock trial.
What happens then? Is the ticking clock included in the first trial? If there's a retrial?
Well, yes. Well, it all depends. I'm not sure what it is on the federal level, but I know on the state level, it's 180 days for like felonies and 60 days for misdemeanors. So I'm assuming the speedy trial clock, it may either reset or you may have just a certain amount of time, because the speedy trial clock is to get to trial. You have but a certain amount of days to actually have the trial. So the trial can take as long as you want, but getting to trial and having the trial is what the clock is about.
Yeah,
Okay.
there's not statute of limitation problems if that's what you were thinking of.
Yeah, well, in terms of
because they filed within the statute of limitations. If there's a new trial, they're still okay on that. In terms of the speedy trial, then yeah, they're going to reset back to the original clock in terms of like he was just indicted. But I if I were the judge at this point, I'd probably grant a new trial, recuse myself, and let it be someone else's problem.
See, that's that's the funny thing. Like that is what I mean, I want to say rational, but that's what a rational person would think. Like everyone already perceives me as being biased. Why would I stay in this trial if only to prove?
I am the judge that apparently allowed this activist campaigning person to be the jury foreperson. So I'm just going to take it aside on this one and do something else with my time.
And now, for someone who doesn't have any idea, how many times can someone be retried if there's a mistrial or
for manifest necessity? Definitely, yeah.
There's no limit.
Okay, that sounds phenomenal.
But the thing is that I do feel like we are making a lot of assumptions. Assumption one is that nobody's probably just they may not have just asked the questions, or the jury questionnaires may not have been sufficient to get this stuff out. She could have answered all the questions correctly and still got onto the jury. So it could be just as bad. Bad questions, bad questionnaire. Next thing you know, you got this juror on who just, and then to be jury foreperson, the jurors vote for that. So it's not like the judge really has any influence. So the jurors thought so much of this person to vote her jury foreperson. So I don't know. I would really have to see, because you to overturn a trial based on this juror's bias, you need a lot. You know what I'm saying? And right now, a couple of tweets are bad enough, but you need a lot to really show that this juror was that biased. She convinced everybody else to be that way too.
So two things. So someone had mentioned that a jury forewoman or foreperson, whatever, is either elected by the jury members or appointed by the judge. Do either of you have any knowledge of that distinction?
No, you got me.
Okay, so there are a lot of questions, because a lot of misinformation, or a lot of people with differing information, where the question would be, if the jury foreperson is nominated by the jury, that's one thing. If she's appointed by the judge, and apparently this was just not a nobody who mischaracterized her bias on a questionnaire, but rather had run for office and was a former political candidate, and she's the only one that we know of the 12 whose identity we know to verify this. There could be more than this on the jury, and then how much blame does a judge have for this? For anybody who hasn't seen the video, I think it's my third one on Roger Stone, in Judge Jackson's order, when she's listing off the examples of why she wasn't biased against Roger Stone, saying he made multiple motions, we granted some evidentiary motions in his favor, we allowed the jury members to fill out a questionnaire, which is typically more than we allow them to do. So it did sound like, even by the ordinary run of things, they don't fill out a questionnaire as a rule, and it was sort of requested and granted, and that's somehow evidence that it was done properly. But it's a legitimate question as to whether or not this jury foreman was appointed by the other jury members or appointed by the judge. In which case,
I think we can look that up right now.
Yeah, see if you can do that while we're going to do this. Joshua Cornelius says this is for the coronavirus apocalypse. Apparently, if you say coronavirus in videos, they get demonetized. And even if you say the beer flu, which is what the what's the word? Not pseudonym, but rather the the other word that people were using, it still gets in trouble. Thank you very much, Joshua Cornelius. I am one of the last remaining optimists as relates to the coronavirus panic. But
yeah, I'm reasonably optimistic given what I've seen so far. I think that the situation is reasonably under control. I'm not too panicked about it right now.
I did go shopping last night, because I'm only worried about the public reaction when the government makes people panic, not of the reaction from the actual virus itself. Viva Frei is in Alberta. I've never heard about Quebec having a different law system. What's the difference between common law and civil law? Care to explain to us non-lawyers? Common law is all jurisprudential in theory. It's case law and authority and one after the other that builds the principles of law. Civil law is purely codified law, like tax, rights of persons, rights of leases. It's all Section 2173. a specific codified section of law, as opposed to common law, which is all established by jurisprudence. And one is the English system versus the French system. That's the big difference.
So I'll answer this another way that might be helpful too. In the civil law system, everything is effectively passed by the legislature, and the law is nothing more than what's written down in the code. In the common law system that's used in the United States and most of Canada, judges have from time to time just invented things. For example, I once covered on my channel a case called Ex Ux, which is the very first assault case ever. It was in England, and a judge just invented the cause of assault from nowhere, just made it up one day, and that's how that came to be. So common law is judge-made law, so you can't just look at the text; you have to look at all the decisions interpreting the text. That's the difference.
Listen to this. This is from the Handbook on Trial Juries. So, Viva, your question again was: are jurors elected, or are they appointed by the judge? Now, listen to this. This is crazy. It says, in some districts, a judge selects the foreperson of the jury. In other districts, jurors elect their foreperson. And in still other districts, the first juror to enter the jury box automatically becomes jury foreperson. The judge will then inform the other jurors the method used in that particular district. So that is the way jury foreperson. So depending on where you are, so now we got to figure out what district they're in and which version they use.
So let's hear this. We know the district was DC. That much we know for sure. So what version was actually used? Interesting here. Thing says Vanessa says Cernovich filed a motion to sign on to Stone's case specifically so he can access the sealed documents during the voir dire. So for anybody who doesn't actually follow Cernovich on Twitter, you should. He posts a lot, and he posts a lot of good information from a legal perspective. He actually posted, it was the one-page motion where he is basically asking to unseal the documents in this particular aspect of the case in the same way he did with the Epstein file. And so it's going to be interesting to see what he can get access to and what it breaks in terms of news. It seems that this particular jury member who became the forewoman was too prominent to have slipped under the radar. And I made the joke that it was very much like Runaway Jury, where at the end of the movie, spoiler alert for anybody who hasn't seen it, John Cusack, under a pseudonym, is a gun rights activist who gets his way onto the jury to sway the jury. Preposterous in the movie, and yet we're dealing with something which is equally preposterous in reality. So follow Cernovich, because he's made a motion. He has said that we could do a follow-up live stream when there's movement on his motion to unseal. So we'll see where that goes. And so that's it. So where it stands with Roger Stone is there was the motion for recusal. Judge Jackson said, no, I'm not biased. We've done a number of things in your favor, almost like she was keeping tabs throughout the trial. And then in the motion says, not only am I not biased, but this motion was strictly a publicity stunt to get the words judge and bias in the news cycle. And now there's still the pending motion for a new trial, which she's going to adjudicate on. And if she grants the new trial, in theory, she's going to be the judge that supervises that new trial. It's crazy. I mean, it is crazy. Let's see what someone says here. Viva, doesn't the jury members have to disclose their jobs to the jury and their attorneys? Who's had experience? Nate, you have to have had experience selecting jury members.
Yeah, no. Our question is asked: what did you do? What's your last? All this stuff. So, but it's standard pedigree. We call it pedigree information. Where do you work? Where do you live? That type of thing. Family information that's relevant. That type of stuff. So, I would assume they did. Maybe they did. Maybe they didn't. But again, we're really talking about political bias here, though, right? We're talking about this. Does this woman have a political bias? And just because you may support the other side, some people will ask about political bias. I would suspect that if I was an attorney in this particular case, and he's such a political figure, I would have asked that question. But generally, your political bias is not relevant in a criminal case. So I'm not even sure if they asked that question.
Well, and something also Robert Barnes had mentioned in the live stream is like, you're in Washington, D.C. anyhow. In the ordinary run of things, 97 of 100 jurors are going to be of one political persuasion. versus the other. So even if the person doesn't disclose it, you know that more than 9.5 out of 10 are going to be, let's call it anti-Trump or pro-Democrat without judgment. That's the demographic in Washington. Like you know it, unless I'm wrong, but I don't think so.
Yeah, but then it's like it's difficult because then you would say, well, Roger Stone couldn't get a fair trial in Washington because 9 out of those 10 people are going to be Democrats. So I think it's like a double-edged sword. Do you ask people what their political leanings are? And if you do, if they say I'm a Democrat, how does it affect? Because like you just said, 9 out of 10 people in the Washington district are going to be Democrats.
Yeah. Someone says, Viva, the motion for recusal could simply be building a case for a new trial. Everything's on the record. True. It could be strategy. You know that 9 out of 10 times your motion for 9.9, your motion for recusal is not going to get granted. And
it's giving you an option on appeal you wouldn't otherwise have. You can't appeal it if it's not denied and you didn't ask for it in the first place. So it's giving you an option on the appeal that you wouldn't otherwise have. So, I mean, I'd ask for it in this position. Why not?
No,
I can always drop it later if I want to, but I open up the options. I want to have as many options for as long as possible. So if I can do this and it gives me the option, I can always decide to drop it later. If I don't do it now, I can't do it later. So why not do it?
No, this will definitely color the file, if not for the retrial, at the very least for a pardon. And I brought up Rhino's question: where is your wife survive all of this? In her closet, car, or wherever you else you talk away. I'm in the kitchen right now, so she's upstairs. She is putting the kids to bed, which is very nice.
I would like. Hello, Rakita. Sorry.
All right, what's up? What were you going to say?
I would like to talk a little bit about Trump's interference in the trial itself and his tweets and stuff, because I think it's an interesting issue with unitary executive theory and the propriety of Trump intervening with the Department of Justice vis-a-vis both tradition and the law. And I think it'd be an interesting discussion. So, traditionally, presidents have not really intervened, at least openly. What they do behind closed doors is a whole other set of concerns. So who knows what they really are doing privately. But Trump tweeting during the middle of an ongoing trial is not something you'd see any prior president do. And so there's a question as to whether or not that's appropriate or not. On the one hand, the prosecutor, the U.S. attorney, is a political appointee, and they can be fired at any time and replaced at any time. And it's not uncommon when new presidents come in to fire them all and bring in their own new people. So, they're political appointees and therefore are subject to the political process. Also, they report to the attorney general, who himself is a political appointee, who of course reports to the president. And the Constitution itself states in Article 2, Section 1, that the executive power belongs to the president. The way it's phrased would suggest all of it, all the executive power. So therefore, the president can give, in the most maximum interpretation of that, can give an order to any federal official at any time to do anything that's within the scope of their power, because their power only exists as a subset of his power. So it's his power, and he's just basically giving order to himself, effectively. It was the unitary executive theory. I think the unitary executive theory has classically been criticized and classically not been well thought of. It is more popular in conservative circles. I think it's growing more popular in conservative circles in particular. But this whole idea of how independent the prosecutors can or should be from the presidents goes all the way back to President Nixon and his interference in the whole Saturday Day Massacre, which is the whole basis of the impeachment articles, or one of the major bases, when he fired multiple people within the Department of Justice. But if you buy the unitary executive theory, he can do that. So that's basically the framework for that issue.
But the thing is that remember the independent counsel statute?
Oh, sure,
The
yeah.
independent the Ken Starr independent counsel statute got away from that because you had an independent counsel by statute, and now you didn't have to worry about the Department of Justice. Only thing the Department of Justice was kind of an offshoot of independent counsel, and that's how with the Clinton probe you went from Whitewater to cigar in the Oval Office. So I've always understood, and the reason why they got rid of that was because they by building in the independent council, it became a fourth branch of government. It became, it can do whatever it wants. You could just fund it as have, it had unlimited funds. It became literally, they said the independent council became, and they abolished the independent council and put it back into the Department of Justice. So I do agree that the Department of Justice's authority is vested within the executive. And I believe as it states now, the president can give lawful orders to the attorney general, all those inline prosecutors. I'm 100%. But my question is, how would you resolve that? Because when they did try to resolve that, they inherently create a fourth branch of government through the independent council statute.
So I think the idea of independent agencies or independent prosecutors is, of course, because this is not the only example where this is. For example, the Federal Reserve, I think, can be reasonably thought of as an executive agency, because what else would it be, right? It's passing policies in terms of monetary policy. Now, the Federal Reserve is independent in large part, even though the people that are there are appointed by the president, confirmed by the Senate, and can be fired under certain circumstances. Under unitary executive theory, and under the most maximum interpretation, then the Federal Reserve, as it's set up, would be unconstitutional. Because the very fact the president can't fire those people directly, or he can't give them direct orders, would be a violation of Article 2, Section 1, in terms of him having all the executive authority. So in the most maximum interpretation, all independent agencies, all independent authority, the independent council would all be unconstitutional. So that's the most maximum interpretation. Under the statute,
just a quick question. All right.
Sure.
Right now, even without the independent council, there are still some federal officers now that the president can appoint but can't fire. Correct. Isn't that what happened with Andrew Johnson?
Yes.
He tried to fire someone, but they passed a law and said. But now, because I know there's these two flavors.
It was a cabinet minister, yeah. It was
so
that he tried to fire.
So wouldn't that? But wouldn't that? Because you're saying that. That would make all those positions that the president can't fire those people unconstitutional. Is that what you're saying?
In the most maximum interpretation, yes, they'd all be unconstitutional. Yes, because
so the president. So you're hinging this on the president having the ability to hire and fire at will.
Yes.
Okay.
I mean, I'm trying to lay out the breadth of the argument, because there's been a lot of talk about this online in terms of the unitary executive theory. And so I'm trying to lay out the philosophical foundation and the most extreme version of it so people can understand where this would be going. But Andrew Johnson wanted to fire, I think it was the Secretary of War, but I could be mistaken.
Yeah, the Secretary of War.
Yeah. The Congress passed what was called the Tenure in Office Act, which specifically said you can't fire him. The president did it anyway, and that was the basis for impeaching him. It is generally considered today that the Tenure in Office Act was unconstitutional, because the president should have the power to fire a cabinet official, the Secretary of Defense or Secretary of War, as it was called at the time. So,
but wasn't it found unconstitutional too? It was found the Supreme Court overturned it later.
You might be right. Maybe it was found unconstitutional, but either way, whether it was found explicitly unconstitutional or not, the idea is that the Tenure in Office Act was unconstitutional because it limited the president's ability to fire. Therefore, all limits on the president's ability to fire and hire at will are similarly unconstitutional. This is not a state of the law as it exists. I'm just explaining the most extreme version of unitary executive theory and where the limits go. So the problem with that is, depending on your point of view, the problem with the extreme version is then the president can fire and hire anyone at will. The good aspect of that is then the people who elect the president. There's no deep state, effectively. When the people elect the president, he can put in place an entire administrative state to his liking, therefore reflective of the people. And there's no legacy bureaucracy that's sitting that he is unable to affect. So, all the Title V entitlements that apply to federal employees, most federal employees are covered under what's called Title V, and they can't be fired except for certain performance conditions. So all that would be unconstitutional. So he could fire the lowest level bureaucrat and all that. So that's either good or bad, depending on your view of how much power the president should have. vis-a-vis the bureaucratic structure. Of course, Congress can ultimately limit the president by not creating the bureaucracy in the first place. You know, he can't administer, say, a Department of Education if it doesn't exist. So Congress could just say, oh, we're not going to give you that authority. You can't administer it at all because it doesn't exist. So there's that power check. But in the most extreme version, or not necessarily even the most extreme version, in a version of the unitary executive theory, what President Trump did would be fully legitimate because he is effectively the chief prosecutor. You know, the attorney general, who is a cabinet official, everyone would normally say is the chief prosecutor. But of course, he's subordinate to the president. So the president's really the chief prosecutor. And so he can just say, well, I don't want to do this. I don't want to go for that term. I don't think this is just. I'm executing a prosecutorial discretion and saying we shouldn't do this. And so the idea of the president's legitimacy in that is part of this question, whether or not the president can or should philosophically have that level of power. So, yeah.
Hold on just one second. Actually, Dapper Dave asked a question here that I would like to, if you guys know the answer to. How can the prosecutors quit the case? They are government employees. You can't just quit. They should have been fired from the jobs.
Sure, they can. They're at will employees. They're at will employees.
Did they resign? So I mean, this might be a semantic thing. Did they resign from the case, or did they resign from their posts?
One of them, at least, resigned from the Department of Justice.
But the one that resigned, I thought was from the Mueller team anyway, so that person was going to leave anyway. Was a Mueller left holdover, but yeah, and the other three resigned from the case. But you can do that though. Well, you can't like resign from the case, but you could tell your bosses, hey, you know, if you're going to do this, then why are you going to have me on a case? I'm telling you, I want 7 years.
There's always the ethics things that apply to all attorneys. You know, one of them is, you know, that you have to be able to zealously represent, you know, you have to be competent, all the rest of it. So you can basically disqualify yourself and say, you know, I can't handle this case because it's a conflict of attorney ethics that I'm bound by. So that's how you would get out of the case. You invoke one of the ABA ethics guidelines. Okay, say I can't do it.
And Andrew Wagon says, wouldn't Stone? Because someone had asked the question before. I don't know who said it, but who was the victim in Stone's crimes? Going back to the no victim, no crime thing.
Hypothetically, the people of the United States, because he lied to Congress, which is representatives.
Well, the people. I've heard this before, but like no victim, no crime. What is that? That is a principle of what? A criminal law in the U.S.
No, I don't know what that means.
No, it's not a formal principle.
No crime, I've never heard that.
I think it's more of a catchphrase than an actual legal principle where they say no victim, no crime, as in to say if nobody was harmed, then no crime was committed. But it's not. I mean, at least I thought maybe it was an American thing.
No, I mean that's
because here.
I mean that's stupid. In the most extreme example, you know, if I was
attempted murder, right?
Attempted murder, right? But you somehow didn't notice that I was trying to kill you at the time, so you don't notice, so you're not harmed because you didn't even know what happened. But of course, it's a crime. Just tried to kill you.
But just so everybody knows, the crimes are like for us. The crimes are against the state. It's not against the individual. So, like for us, all our prosecutions were the people of the state of New York. Because even if you assaulted somebody, your crime is not against technically them. It's against the state.
Yeah, that would be the difference between criminal versus civil wrongdoing, where one is against the state, the other one's against the individual. So wouldn't Stone's criminal victim be the Democrats? Then wouldn't having a Democrat on the jury judge be a conflict? My understanding is that political affiliation is not a grounds for dismissal from a jury.
No, it's not an inherent conflict. I think the scale of this particular nature of this particular Democrat is what caught my and everyone else's attention. It's not that they're a Democrat, it's that they're super activists, have made many social media posts, and don't seem to be able to be unbiased. That's the problem. So
I don't know if anybody's
being a Democrat.
If anybody's out there who's sat on a jury, have you been asked if you were a Democrat or Republican? Because I've never asked that question. I don't even remember people asking. But I would suspect in a trial that's politically charged, you may want to delve into that. But generally, that's just not a question you ask. It doesn't matter if you're a Republican or Democrat. Can you come to a conclusion based on the facts?
Well, so I mean that is the. I'm trying to think of like a religious analogy. If anyone could ever be asked what religion they are when sitting on the jury to determine if they can sit on a specific matter, but it would be like I mean, I guess the thing is, it would not be the political persuasion that would be the issue in this. It would be the activist persuasion on social media. Like, imagine in the era of O.J. Simpson, if someone said, "No, I don't watch football and whatever," and it's, okay, fine. But if there was a Twitter back then and you saw someone making negative comments about O.J. Simpson, yes, that would be the bias against the accused that would get them right off the jury, out of the jury pool. And apparently some of these tweets were specific to Roger Stone. They were specific to the Trump administration. They weren't the political party side of it. It was just the bias, preconceived notion side of it that was over the top.
I saw someone in chat ask if I was saying that Trump does have the right to do this, and I was trying to outline the argument in it. I wasn't personally saying my opinion as to what Trump could do. I was simply saying that under unitary executive theory, because this has been a topic that's popped up a lot on YouTube, that this would be a thing in some version of it that Trump would have a legitimate right to. Now, whether or not he does is a whole other set of problems, but I was trying to delineate the argument.
Just to let people know, the way it works now is that there's kind of two levels of government employees. There's the executives are the ones that are appointed by the president and confirmed by Congress. Those appointees, whoever he appoints and is confirmed by Congress, he can fire and hire. He can fire at will. Those are all at will employees. He can fire them at will. But then you have like another level where there's like a contractual agreement, 1 year, 3 years, or something like that. It may even be put into the statute, and he can't fire those people at will, or if the statute says he has to fire them with cause. So those are like the two different levels. But there's one level where he's definitely can fire them for whatever reason, and there's another level where it really depends on how the statutes word. If the statute says they get a certain amount of time, or if it's like for cause or something.
All right, excellent. We got Real Bambooga says, if intent follows the bullet, would considering the people as victims work as much for Stone as it would work against him?
No, I don't think so. They're trying to say that, because that would be the same in every kind of criminal case. The criminal defendant is one of the people too. So when you say the people versus uncivil law, for example, well, I'm part of the people, but I'm the one who's, made an affront in this analogy. So no, I don't think so.
All right. Mandatory carry, just because I know he's at work. Keep fighting and co-posting to BitChute. I actually don't post to BitChute anymore, but I know that I have people, not anyone that I have any affiliation with, who are actively posting all of my content to BitChute. So
nice.
It's there. I don't object to it. I don't ask for it. So anyways, thank you very much, guys, for the super chats. Okay, no, but the one thing you mentioned before, Kurt, the tweeting. I have actively, I don't actively like take positions or whatever, but I did proactively, just to show that I can be objective and non-biased, suggested maybe Trump should stop tweeting publicly about pending court proceedings, because I have two theories about this. Like, I would rather know what someone is thinking rather than hide it. So go, by all means, make your intentions public so I can know what you're thinking. It's not like because he's not tweeting it, he's not meeting with Attorney General Barr behind closed doors saying, you better do what I'm telling you to do. So I don't believe that the absence of tweeting means that it's not happening, and I prefer to see the tweet and at least know what's going on. But it creates the perception where you're creating fodder for those who are going to say this is interference. Now, Trump tweets about it and people allege the interference, and then when you find out that Bill Clinton's having tarmac meetings with Rice, there's no tweeting about it, but that it's going on anyhow. Yeah. One way or another.
That's the counterexample right there. It's like, oh yeah, and according to everyone, all they were doing was saying hi on that plane. Sure.
I mean, it's so preposterous to anyone to think that there's nothing. A tweet is incriminating, but a tarmac meeting in secret that was only disclosed but by, I forget who broke that story, by accident. Yeah, there's nothing sinister about that. It's an inconsistent double standard. Both are inappropriate. I just think that there's some benefit to the transparent inappropriateness as opposed to the concealed inappropriateness.
Well, hold on, but there is a difference, with somebody's being investigated versus somebody being on trial. Like, when you're on trial, there's a whole different aspect to it.
They're definitely they're not 100% analogous. Although some might even argue that on public trial and having a public tweet is much different than being private investigated by the FBI and a private meeting with the FBI. Some might even say that one is worse than the other. Okay, Al Dente says, how can we, the people, charge Schiff for lying to Congress?
If wishing made it so, but Schiff was not under oath at any point when he was giving his statements to Congress. He was just when he was in the Senate, he was as an advocate. So the same reason you can't charge a lawyer in court with perjury, because whatever else they might be doing, they're not under oath at the time.
Yeah, except Kurt, there was a push to suggest that Trump's attorneys could be disbarred for lying for his representation. But
if you want to try to disbar Schiff, then sure, go for it. You can write a complaint to his bar counsel about all the lies again. I'm sure they've got a few already, but feel free to add. Yeah, we'll see how that goes.
But would he get immunity because he was on the Senate floor though?
I would think 100%.
That's actually a really good question.
That's a good question, right? Because he is a member of Congress and he is speaking on the Senate floor.
That's
in the courts. Hey, look,
that's an insanely smart question, because there's a provision in the Constitution called the Speech and Debate Clause, which says that when a person is speaking in Congress, that shall not be questioned in any other place. Kurt. So Nate is right. You could make an argument that anything he said is completely immune, even from the attorney ethics guidelines. Toast to you, Nate. Good point.
Kurt, it's the Elizabeth Warren. It's the Elizabeth Warren defense to the tweets that she made about Nicholas Salmon was the debate clause by extension, that when she tweeted, it was in her capacity as a government representative, and she got
This is different because he was actually.
You're right. I apologize. I was not saying you were wrong. I was saying that she was wrong. Yeah, I don't think that what she was arguing makes any sense. I don't think the speech and debate clause or qualified immunity or whatever she was trying to sell works. But when you're actually on the floor, like the floor,
when you're actually there,
I think you're in a whole new world.
because she's trying to say I can tweet and I'm covered, but the Constitution says he's on the Senate floor, he's a member of Congress, and he's speaking. It hits. That is where it's at. He should be immune.
Kurt, you should knock on that bottle just so you could be knocking on the door.
Someone asked, and so I answered their question.
I'll show you what I've got in a second. It's back in the freezer.
I wonder if this person's going to tweet, going to give us a message back now, because now we think that Schiff is immune from any type of ill will.
I think he is. I mean, I think it's a no-brainer. And like, if and then the difference between a lie and a hyperbolic statement or an exaggeration or whatever. I mean, now I think I just use hyperbolic, and so I'm in the Tim Pool field of language, but
it's complicated. Gotta listen to me.
It's complicated.
Okay. Call me, Schiff. I got you. See, I just pulled that out on the stream live. Boom.
Okay, so I don't think there's anything for Roger Stone. I don't think there's anything more that there's not much to talk about. We're going to have to see where it goes. By the way, let's make some predictions. 52 minutes, 40 seconds. There's more than one jury member in that pool that is severely tainted. And if their identity ever becomes known, I'm predicting it out front. I would say that pool, even if it's 11 on 12 that should be Democrat, there is tainting in that pool, and I suspect it was at least part of the influence for the gag order. Oh, this is one thing. Sorry, collective knowledge of the internet. Is the judge's gag order still in effect now post sentencing of Roger Stone? My understanding is yes.
Juror, then yes.
Say that
again? Yeah, I would say yes.
The juror who added or something, yes.
Okay.
Yeah.
So I mean I don't think we're not going to get much more to the Roger Stone. I think it's been tremendously interesting, but EW claimed Native American on school apps fraud. Oh,
quite possibly. Yeah, quite possibly. Especially if she got any sort of money for it or any kind of scholarship for it, then yes. Unfortunately, the statute of limitations is almost certainly long past. But yes, it probably was fraud.
Nice.
Or it's arguably fraud.
Even if she's 1/1000th, it's partially true. It
was like 1/2000th, and I don't think it qualifies. No, I did a case on my channel recently where a guy tried to get minority grants for being African American because he did an Ancestry.com test and found he was 7% black, even though he looked suspiciously white. And the government didn't buy his black claim, so I'm not buying Elizabeth Warren's 1/2000th part either.
It was 1/1024th. Let's not exaggerate.
I know. For the LSAT, right? You have to one of your parents has to be that whatever race that is or whatever. Like it has to be like 25%. It's some crazy number. Like they actually have a number.
Real Bambuga says, I'd really appreciate it if each of you could read the following. It's how many? It's 1, 2, 3, 4, 5, 6, 7.
yeah.
It's complicated.
It's complicated.
All right, Nate. Nobody's gonna twist your arm. Okay, so here's the deal. Roger Stone. I don't think we're getting much more out of it. We're gonna see where it goes. We're all gonna be on it because I have a playlist now. I have a Roger Stone playlist, so I gotta follow up every time. For everybody who knows, I have the Jussie Smollett playlist. I'll update that when there's something material, not just another indictment. But yeah, so nothing. I don't think Roger Stone. We'll see where it goes. We'll see what happens. We go. Okay, just in time for the next subject because we're going to move on to Akilha because that one's cool. 55 minutes. It'll be about 57 minutes. Akilha, obviously, Carl Benjamin. But before that, Dapper Dave. Question for Uncivil Law on the coronavirus issue. Can Trump declare a national emergency and force private companies like pharmaceutical companies to join on finding the cure for the virus?
Probably not right now. I tend to, at least in this respect, agree with what Legal Eagle was saying, that when you're looking at what the government can do in these kinds of emergency situations, it has to be proportional to the need and harm. There is, I know it isn't quite the question you asked, but there are some cases in patent law where there was a particular cure that was known, that was under patent, and the U.S. government said yoink, and the Supreme Court said it was okay because of the nature of the particular emergency at the time. I think that there's this famous idea that the Constitution is not a suicide pact. So I think in case of true exigency, the courts will bend pretty far when it really comes down to it. They'll bend to martial law. We've had martial law in the United States before, in different parts of the country at different times. So yeah, but I don't think we're at that stage yet.
Well,
yeah, because don't forget, like remember the example of who was it, Roosevelt, that tried to steal manufacturers, and he tried to force them to go back to work, but it's Truman.
Yeah, but it didn't work in that case.
Yeah, because they said it wasn't as much need, but even in that opinion, they said that the United States government, in other words, something like you said, where it's not a suicide pact, where there could be the need for something like this, and if it was, then the government could commandeer, because survival of the government is paramount to the Constitution.
Well, so I think the government can order quarantines legally. I just think it has to be reasonable, and I think it just has to be shown to be understandable and stuff. And so if they can demonstrate it, then I think ultimately they can seize it. Sure. Well, we're not there yet.
No, but I also think that, I mean, not know, I have no expertise in this question at all. And I would just think that the difference between forcing private companies to join finding a cure is different than removing a patent, removing exclusivity, forcing the production of a known formula. You're saying like discover something that might be undiscoverable because there may not be an actual cure. So what one is what's the word? Not democratizing, but rather making public something which exists already, versus this question, like go find a cure. There may not be a cure, in which case you're compelling action as opposed to removing protection type thing. I would imagine that would be the distinction. But it's eliminating a patent to force the production of something that exists is one thing. Making people look for something you don't know if it ever exists, like go find a cure, go make the H-bomb, would be sort of a different. I would imagine would be a different level. But I haven't watched Legal Eagle's video on that subject yet. I find this whole panic to be, it's putting me off in terms of the prevalence that it's taking on in the news. But okay, so hold on. See, we got Bud Light viruses. That will not work either. Finn screen name. Apparently, they know. Okay, 59 minutes. We're going to be there in about 15 seconds. Akilha, obviously. Have you guys been following this?
I have not.
Kurt, have you been following this?
I have been learning. Yes.
Okay, so shall I summarize the facts, or do you want to do it?
I'll summarize the facts, but first to the person who asked me about the patent seizure question. I don't know at the time what the court did, but it's now codified at 28 USC 1498. So if the government wants to seize something that's patent, they can do so. and only have to provide reasonable compensation, which would be like manufacturing costs. So I don't know what the decision of the Supreme Court was, but it's codified under statute now. But anyways, to the issue that you asked me about, because I want to answer a super chat. Yeah,
Wait,
so
where was there a super chat?
there was a $5 super chat that asked me that question. That's why.
Yeah. Okay. Sorry. This one I did not. Is it?
Yes, that was the
Okay.
one I was
Good.
answering.
Sorry, Real Bamboo. I missed that.
I'm keeping up.
Okay.
But,
now I'm noticing his avatar, and now I'm comparing it to the Pete Buttigieg picture that was circulating, where everyone was picking on everything that was wrong in the manner in which his avatar. This looks like this is a good looking avatar. Okay. Sorry. Distraction aside. Thank you, Real Bamboonga. Okay, Kurt.
So Akilah Hughes, Akilah obviously produced videos and produces videos that can be categorized as being in a social justice warrior, left-leaning, woke kind of nature, if you're so inclined to describe it that way. And one of the videos she produced was "We Thought She Would Win," obviously referring to the Hillary Clinton campaign and how she thought that she would win, and they were really sad. And then Carl Benjamin, Sargon of Akkad, produced a video that was a cut of her videos. So it was no other commentary other than the title, which was RIP, Social Justice Awareness, or SJW Awareness.
SJW Levels Awareness.
So RIP, SJW wasn't awareness. So other than that, there was no commentary or voiceover. It was just juxtaposition of various videos that showed lack of self-awareness and lack of, or contradiction in thought. So that was the overall message. It can be thought of as critical. Then Akilah Hughes, upset about this, sued, and in her pleadings basically said, yeah, this was really critical of me. And the judge kind of looked at that and say, well, criticality is one of the fair use factors under 17.
In fairness, she said demeaning and degrading. So
whatever. So that same difference to my mind. But yeah, it is one of the basis of 17 USC 105 fair use is criticism and commentary. So either way. And so, yeah, the judge, who knows what happened to her first lawyer? Her first lawyer withdrew. And as you noted in your case, when that happens, it's usually not a super positive sign. And then the judge said, yeah, I think you're going down in flames, basically. And I can't figure out whether to do it now or under summary judgment. But basically, I'm going to rule against you. And you might want to plead, might want to reach a settlement. And Akilha threw out, what was it, like $40,000 or something?
Yeah, $46,000 for the alleged copyright infringement.
And then Carl was like, no, because that's going to cost me more than my attorney's fees. And by the way, good for him, because he got one heck of a deal on attorney's fees. I was surprised in his motion for attorney's fees that it was so low. I was like, $33,000. Like, geez, where are you finding these attorneys, Carl?
Yes,
good for you.
It's the best advertising for that attorney's office, except now everybody's going to be calling them up for a discount when they
Yeah, no, really. So, but they filed just on motion to dismiss 12B6 failure to state a claim. Based on your pleading, based on the surface of your pleading, you've got nothing. You've got no legal argument. And the judge said, yep, motion to dismiss granted. And now they're considering the request for the legal fees. And I figure there's about a 95% chance that they're going to be granted, given the prior warning from the judge. So I figure the odds are pretty good.
Yeah. Now, and that summary of facts, pretty good. Two minor details. Akilah, obviously, his original video was like close to 10 minutes. Sargon's video, which was only the edited portions of it, was 1 minute and 51 seconds. So roughly 25% of the length of the original video. Okay, now, and then Kurt, so everybody knows, I have a few people that are my go-to people to get information that I think I'm lacking. And I called up Nate on this to understand the difference between, just to make sure that I understood it, because I thought I did, but the difference between a motion to dismiss on a Rule 12 versus a motion for summary judgment. So Nate, I don't know who wants to do that one and explain.
I'll do it. So a motion to dismiss is just based on the pleading. So it's based on the initial filing from the plaintiff. And so you respond with a motion to dismiss, and just says, based on what they filed, if everything they say is true, because we don't need discovery. Why would we?
Yes.
We're just going to assume every word they're saying is true. That's what we're doing. So if every word they say is true, do they win? And if the answer to that question is no, then motion to dismiss because you haven't stated a valid claim. Because if we take everything you say is true, you don't win. So why bother going on? So then a summary judgment is like saying, okay, there's some issue that we need more information to figure out. So then there's discovery, which usually entails exchanging of documents, usually entails some sort of depositions from both sides. And then you go to summary judgment and say, okay, now based on the evidence we have, we can say that there is or is enough for a reasonable jury to make a decision. So based on all the evidence that we've developed, could a reasonable jury find for plaintiff? If the answer is no, because there's not enough evidence, then we'll dismiss at that point. And the answer is a reasonable jury could find, then we'll go on to trial. So that's basically what we're doing. So we're just basically saying on your bare bones initial pleading, if every word you say is true, you lose. So go away.
On a motion for summary judgment, do you have like a joint declaration where we say we agree on these set of facts type thing?
No. You just say the plaintiff is everything. The defense says every word the plaintiff says is true, and they still lose.
The standard.
Oh, sorry.
I think the standard. I think the standard is that is whatever the plaintiff said, all allegations are accepted as true, and the plaintiff is even given, or the non-moving party is given all favorable inferences. Right. Non-moving party allegations are accepted as true, and they're given all favorable inferences.
Is that on summary judgment, or is that on a motion to dismiss?
Motion to dismiss.
Okay, no, so that was the question. So that's the motion to dismiss. Motion for summary judgment. You've done depositions, you've exchanged documents. When you moved for a motion on summary judgment, is there an agreed statement of fact between the parties typically?
No, not usually.
No, I think it's still the same standard.
It's just the same standard. It's just basically saying it's the same standard of like, okay, on your surface pleading, you made a plausible case, like well,
hold on. There's an example, a real world example. Nicholas Salmon. Because Nicholas Salmon at the beginning, there was a motion for summary judgment. They didn't state a claim because they didn't get a couple of the elements for defamation wasn't satisfied. The judge said, okay, case dismissed. They came back. They said, well, these three that are borderline enough. So the judge said, okay, with these three, we're going to go to discovery and get evidence to see if this three, and if these three are, and then after discovery, he'll entertain a motion to dismiss. Okay. And the motion to dismiss is saying, hey, now you've got all this information. Has it changed the fact that you haven't stated changed the fact that you've not stated a claim? If it does, then we go on. If it doesn't, then there's nothing for us to do. So
okay. And if I didn't say thank you, Real Bambuga, before, thank you very much, Bambuga. There was another one that I want to get to. I just skipped over it right here. Here's 6.71 Canadian. Oh, Leif, thank you very much, Sandy. I thought that was like the proof of the beer or something. Okay, so they didn't do depositions. They said take her motion on its face, take for granted the allegations, failure to state a claim, dismiss it now. Judge says, my recollection was quintessential fair use.
Yeah.
The fact that Akilah felt.
Now, hold on.
Oh, yeah, go ahead.
Yeah, quick question. So if it's fair use is an affirmative defense. That wouldn't be that's a 12B6 motion, failure to state a claim, because isn't that an evaluation of the factors? It wouldn't be.
Well, that was one of the questions. That was one of the questions the judge was asking themselves, if it had to be at that point or not. And I know there's been case law on trademark law on this, that it can be done in a motion to dismiss for fair use on trademark. I believe it's been done on copyright as well. So I don't think it's like the first time a district judge has ever said that I can evaluate it. You're right. It's an affirmative defense. So they have to put forward enough in the response. But there's the only evidence. I mean, the only evidence that really matters is the two videos, right? The original videos and the infringing video. So it's like, put it on the record. It's like, well, can I make a decision looking at these things? Okay.
I do think that the admission that it was demeaning and demoralizing. I think there were two words they used. I think those were sort of determined in that there was almost sort of like a judicial admission that there was something transformative in it. So you don't need to get to a trial to determine the transformative nature, because if it were just copyright infringement, just unlawful reproduction, it couldn't be demeaning or degrading or demoralizing. And so by virtue of the fact that in her pleadings and in her argument, I don't think it was argument, but in her pleadings, she alleged that it was demeaning, it was necessarily an indication that it was transformative and therefore maybe something else, but not copyright infringement. That's what I think the distinction was. in terms of the dismissal, because it was a dismissal on the 12b6. That's my understanding.
Okay.
Can you plead insanity in a copyright suit? Al Dente, thank you, but no.
Unclear, because copyright is strict liability, so it doesn't require a mens rea. So because there's no mens rea requirement, I don't know if you can plead insanity. It would be interesting to try. But I'm gonna say no.
I'm going to say yes. Automatism is an absolute exoneration of any criminal liability.
Yeah.
So, by the way, I should show everyone what I'm drinking. It's Geneva, Amsterdam. It's not good. It's not good. It tastes a lot like the Kuiper gin. If anybody knows what that tastes like.
So it's gin.
Yeah, it's gin. It's a Holland. It's like a Dutch gin, so it's like got that very tequila type flavor to it.
By the way, because someone asked earlier in chat, and I haven't had a chance to respond yet, I did videos on the Vic Mignogna case. I've done videos. So if you're interested in my take on the Vic Mignogna case, you can go to my channel. Long story short, I think Vic Mignogna's attorney flubbed the case. I don't think Vic is going to win because their attorney flubbed the case.
Okay, so
but that's the short version.
This might be more interesting than the Akilha. Let's get to this. Let's get to this in this particular stream.
You want to talk about Vic?
Let's see. What else do we have for Akilha? Akilha. So, what's his name?
We don't think she's gonna win it.
No, I think it's
over.
Okay,
right?
No. I think she's going down. She's going to pay the money.
Okay,
that's what I think is happening.
There's nothing more interesting in that. The only novel aspect of the decision granting the motion to dismiss was that editing without commentary can qualify as fair use if the editing itself creates commentary. So that's the only interesting thing. Okay. Vic Mignogna, since the beginning of my vlogs, people have been saying, do Vic Mignogna, do Vic. And I said, Nick Rechieta is doing it so well already and so thoroughly, and he's getting the depositions. I want to have nothing to add to this. What's going on with Vic? From the beginning to present.
So the Vic is a voiceover artist. He's most notable for doing Borady from Dragon Ball. And he was essentially accused by some of his co-workers at Funimation for engaging in misconduct of potentially sexual nature. Some of this misconduct allegation I thought was super weak sauce and didn't amount to anything. And I was amazed that they brought it up. But anyway, the allegation from Vic's side was twofold: defamation for making these allegations public, and for not making it clear. When Funimation fired him, they said, we essentially, I'm going to paraphrase this, but said, we don't tolerate people who engage in misconduct of whatever they said. And then in a separate tweet said, and we have fired Vic. So you could read the two together as saying that Vic had done those things. So there was a defamation argument. Then there was the tortious interference argument, where these people who had worked with Vic and their fiance, in the case of Monica, I believe it was, called various conventions that Vic was scheduled or thought to appear at, said don't let him appear because of all the bad things he did, and his contracts fell apart. So it was defamation, tortious interference with existing contracts, tortious interference with prospective contracts. These were the causes of action. This was brought in Texas. Texas has an anti-SLAPP, which is strategic lawsuit against public participation. It's called the Texas Citizens Protection Act in Texas, which I'll have to learn about soon because I'm soon going to become a member of the Texas Bar. Anyways,
yeah.
So they filed this and they won it, and I read the original filing, I read the response, I read the TCPA notice, I read that response, what's the
TCPA notice?
The anti-SLAPP.
Okay.
It's called TCPA in Texas, Texas Citizens Protection Act. And I read the dismissal hearing where the attorneys talked. And my overall impression is that the attorney who filed it flubbed the case. He filed a bare bones notice pleading. It appeared to me, at least, that he thought that he was going to be able to supplement on the back end. It appeared to me that he got surprised by the TCPA that put in place a discovery freeze, so he couldn't do what he thought he was going to be able to do. And it appeared to me at oral argument that he didn't know like what he was arguing, and the judge was getting increasingly frustrated with him and basically gave up patience and ruled against him because he didn't like him anymore. And I don't think he's going to win his appeal. That is my summary of what I think happened.
Okay, I'm going to have I'm going to have questions to you right after I address these super chats. Can you plead insanity to a copy strike? Okay, Real Bambuga, thank you very much.
Same problem. Who knows?
Okay, and we got Real Bambuga, Viva, Frei, Uncivil on Nate Brody. Can we get a live stream through a breathalyzer test? I believe I answered in the comment section. I don't know what Nate's drinking, but the answer's going to be no for me. And
I got water.
That's water in Russia is vodka.
And
then we got very interesting discussion. Ted Park, thank you guys all very much for the super chat.
This is 55% not alcohol.
Mine is 58% non-alcohol. Okay, so hold on one second. So Vic Magnota is sorry, I just hit my mic. Vic is suing. Vic is suing for wrongful termination, defamation,
tortious interference. Yes.
Who files the slap?
The other side did. Funimation and Monica and whatever else they listed.
A slap suit, the strategic lawsuit against public participation, alleging what? Alleging
essentially that Vic is just trying to silence valid free speech. That the speech, that what they said was completely valid, and this is merely a suit designed to harass rather than seek a valid legal claim.
Okay, I'm going to ask some questions. They may be stupid, they may not be stupid. I thought this slap was a defense to a lawsuit. Let me rephrase. Okay, no, because I'm thinking like the slap is a lawsuit which is intended to prevent someone from doing something proactive as opposed to availing someone to their rights. Like, why would it be a slap? Why would it be a slap to dismiss and not just a motion to dismiss?
Well, okay. Sometimes from the defense's perspective, you call it an anti-slap because sometimes you would call what the plaintiff did slap.
Okay.
So the plaintiff is filing the slap. The plaintiff is filing a strategic lawsuit against public participation. So sometimes you would, from the defense's point of view, call it anti-slap for that reason. But sometimes I mix the terms when I'm not being precise. But the reason is because this has been a balance that has been struck by different states in different ways. Traditionally, all you would have is the motion to dismiss. The problem is that lawsuits, as I'm sure you're well aware, can be quite expensive. And so even if you can win at a motion to dismiss or motion of summary judgment, depending on what that is, you're looking at tens of thousands to potentially six figures, even if you're going to win that. And so the idea was we as Americans value freedom of speech. We think it's a paramount value. And so we're going to create a special rule for free speech based issues so that you can get out of this if it's valid free speech with the bare minimum of cost. So you don't have to worry about being forced to settle because of a bogus complaint just because you don't have money. We're going to give you a remedy to short circuit the whole thing so that if what they're trying to do, if it's Bob Murray, a la Cole, a la John Oliver, for example, who's suing, and John Oliver saying, well, I'm just criticizing you because you're a jerk, we want free speech to exist. So the motion to dismiss was not considered sufficient to protect the interests of free speech. So we created a whole new thing in some states to create this plus. So that's one way of thinking about it.
Okay, and it's very interesting. We got Al Dente says, I have worked with Vic as a convention staffer. He is a broken stare and had been banned from conventions and even entire states. We had been silenced. Yeah, but that's the other thing. This termination and defamation doesn't seem like a free speech issue. It seems like especially the tortious interference is not free speech. It's contractual and not. Okay, I mean, I don't understand how the slap even figures into that, but I don't know how broadly the slap statutes have been applied in the states.
Well, they're state specific. So every state that has one, they only exist as a creature of state law. Okay. So there's no federal anti-slap yet, and there probably needs to be one because there's disputes right now as to whether or not they can exist in federal courts when they exist in state courts. So there's a whole dispute on that issue. But like Texas is considered one of the strongest in this. So Texas's version of it is very favorable to free speech. You know, we love free speech, we want free speech, and so we're going to look very critically at any lawsuit for defamation in particular, because we want free speech to exist. We want you to express your mind and not fear this repercussion. So we're going to create a whole new avenue for you to crush the people who are trying to oppress your free speech.
Yeah, by oppressing their free speach. I mean, I'm going to get to that in 1 second. That something pisses me off there. Hold on. Don't do drugs, Nuvi. Don't tell me what to do. I'm joking. Thank you. Thank you very much for the super chat. Bamboo, come on, admit it, guys. You're drinking water and showing alcohol bottles for CYA cancel culture deniability. I always am reluctant to admit to it. You drink alcohol and like do it on live chats. I feel almost nervous. We've got head jobs. If a startup pierces the corporate veil by failing tax on time or filing annual Delaware Inc., can corporate protections be restored to full integrity?
That sounds like a legal question.
Okay.
That's a very precise corporate law question.
Head job. Thank you very much.
Delaware specific law, for example, because again, corporations are state specific, so you have to look to Delaware specific corporate law when it comes to corporate veil and piercing of it. But generally, when you pierce in the corporate veil, it's only for a specific thing, not for all things.
All that
general proposition.
Contact an attorney in the proper jurisdiction. Which is Delaware. But now this is the funny thing, because like you talk about the SLAPP statute is intended to protect freedom of speech by penalizing lawsuits that would offend freedom of speech. As far as I'm concerned, I regard a lawsuit as an extension of freedom of speech, and by prohibiting someone's right to file a lawsuit, the SLAPP statute is itself penalizing free speech, which is I want to exercise my freedom of speech by pursuing something before the courts. It's almost paradoxical. Okay. In my rant.
I mean, that's a valid policy perspective, and not every state has a SLAPP, anti-SLAPP.
Yeah.
And not every state that has one has gone as far as others. So it's an issue of legitimate policy debate. So
Vic's lawsuit was dismissed.
Yes, under TCPA, yeah.
After depositions, because I know Riccietta was going through the depositions, and he had hours of live stream on the depositions.
I don't know what depositions were done before the discovery shield went in place, because TCPA, this again is Texas specific. I'll know more about it soon when I become a Texas lawyer. But TCPA puts in a discovery shield, which prevents some discovery from occurring. But he might have had, I think he had, may get this wrong, but he had some, and they might have been unsworn affidavits. But he had some affidavits which were attached to the original complaint. The original complaint was killed because it was improperly notarized, as I understand it, and I could be mistaken here, but as I understand it, by the attorney who notarized it when he wasn't supposed to. So that didn't work. So all those all the evidence that was attached was killed. He tried to file a second amended complaint, which was denied because of the time period. So all the evidence attached to that died. So I'm not sure any of those depositions are actually on the record. Well, so there might have been some depositions that occurred, but I don't think they're on the record.
Apparently, my understanding is that there was no gag order in effect for the depositions, and therefore they were free to be publicly disclosed. Whether or not I agree with that explanation,
yeah, they were attached. They were attached to the original filing, so they're court filing. But whether or not they're being filed and being on the record are not the same thing. Yes, they were filed.
That's
are
true.
They on the
Yeah.
record? I don't think they're on the record. I don't think it's part of the record of the case.
Oh wow,
Nate! People want to hear you talk. What are we going to ask you here?
I don't know. I'm learning about the Vic case too. I'm just thinking it's fascinating. I'm listening to the back and forth. I think it's interesting.
The Vic case was crazy because there are tens of thousands of people who are in the field of like anime, and when Riccietta was doing it, I mean, he was holding live streams on the subject, and there were 30,000 people watching the live stream. It was crazy, and I remember some questions I was asking him because they were going over depositions that were not filed yet, and my question was how does that happen? But anyways, I'll say it's a phenomenally interesting case. I might do a cursory overview of it now, but I still feel like I'm so far behind the ball on that I'm better off just leaving it to the people who have been involved in it from the beginning. But Mike Lombardo says, yeah, the depots are absolutely a part of the court record. Okay, that's good to know. If it's true.
Yeah, this is an issue where the Vic people who are following this think it is, and they might be right because they've been following the case way closer than I have.
Well,
So they might be right, but I'm a little bit more dubious based on my limited understanding.
So, okay, we got Mike Lombardo says, if you read the September 6th, see, this is the problem. Like trying to cash up on a file like this, where we would be discussing with people who have this level knowledge of experience in the file. If you read the September 6th hearing transcript, it's pretty obvious the judge messed up pretty bad. I do not agree. I do believe he will win the appeal.
I don't agree. I did read the transcript. In fact, I live streamed the transcript and my reaction to the transcript. I do not agree that the judge messed up the hearing. It seemed to me, at least in my humble opinion, that Nick's lawyer did not know what he was arguing. He didn't have it together. He didn't know what contracts he was talking about. There were several points where he gave very vague answers, and I just saw the judge getting increasingly frustrated with him. And I don't agree the judge flubbed. From what I read, it seemed more that the attorney for Vic flubbed it, not the judge. That's that's my view, though.
Any criminal charges against Vic or nothing? Criminal civil lawsuits by the alleged victims?
Not as far as I'm aware, no.
Okay, interesting. Now, okay.
No, I wasn't at the courthouse, August. No, I wasn't there in person. I did read the transcript, though, so maybe it seemed better. Maybe it seemed different because it seemed different maybe when you were there. It could be. But yeah, no, I don't know. I wasn't there in person. I just read the transcript. So okay, my impression.
We got Jorge Fabrizio says, have you talked with a PragerU versus YouTube? Nate, I think you want to talk about this one?
Yeah, I actually like this case. I think it's interesting.
Get me out of trouble with the Vic people, please.
Oh my God, you and the Vic people. You guys are going into some serious detail. You're talking about transcripts on September 6th, and the judge is like, wow, you guys.
I'm 3 levels up. There's Riccietta, who's like top level. Then you got uncivil law, and I know the summary stuff, but I could never get into it.
I will say this about Nick. I really respect him as an attorney. When I was listening to his 2 most recent live streams where he was responding to the filings from Ty's lawyer, he said a couple things where I said to myself, oh, that's really clever. There's like 3 or 4 things where I said, oh, that's a really clever idea. And so I know that Nick has some clever ideas. Whether or not the attorneys that are actually representing Vic will use any of those clever ideas is a whole nother story. But I think he's very deeply informed on the case. So I respect Rikita's opinion. He has a much more informed opinion. I think he would even agree, though, that his opinion is biased. I think he would agree himself that he thinks it should come out a particular way. I consider myself a little bit more neutral. I think, based on what I understand, Rikita is more optimistic than I would be. But I'd love to talk to him about it sometime. It would be an interesting discussion. But he's greatly well informed, and he's very smart. He
would be open for it for sure. Okay, PragerU versus YouTube, because I know that Nate knows something on this. Nate.
Yes. Well, it simply comes down to this. PragerU's videos were being both demonetized and restricted on the platform, right? So for those of you who don't know PragerU, it's would you guys characterize it as a very right-wing conservative think tank group? Started by, what's this guy's name? Daniel Prager or Dave Prager, something like that?
I never knew it had right or left leaning ideologies because I had always seen it addressing issues that were both left and right, but apparently
because I read up on when I was looking at the initial lawsuit, it was deemed as like a conservative think tank or conservative leaning university. But anyway, one thing that they were saying was that PragerU was saying that because they have their views of being conservative, that YouTube was directly targeting them through the algorithm, and they're targeting conservatives through the algorithm. You can't, say certain things. Your video get demonetized and restricted. And restricted means only people above the age of 18 can watch your videos in this case. So they were having all of these problems. So they sued YouTube, and they sued YouTube for violations of both the First Amendment. I forgot the name of the act they sued them for, the Latham Act.
Lanham Act, yeah.
Lanham Act, yeah. And And it all cruxed on the one issue that it all turned on was, can YouTube be considered a government actor? Now, there was the case that PragerU was really relying on is Marsh v. Alabama. And Marsh v. Alabama, there was a company town. And what happens is Miss Marsh went to Alabama, and she went into Chickasaw. I think it was called Chickasaw, Alabama. She goes into the street corner. She starts handing out Jehovah's Witnesses flyers. The police come up to her and say, "Ma'am, you can't do that. You're on private property." She looks around. She says, "Listen, I'm in the middle of a town in America. I can hand out my flyers." They arrest her for trespassing because she is technically on someone else's property, and she sues for First Amendment violations. It goes to the Supreme Court, and Supreme Court rules. Now, in American law, the Constitution is only a bar to government action. It's not a bar to private action. So if you are someone, the government must give you free speech as a citizen, but I don't have to give you free speech as an individual. So that's the difference between me being able to kick you out of my home versus kick you out of a public park. So what happens is that in Marsh v. Alabama, the Supreme Court in this case determined that a private company or this private town would be subject to constitutional restraints because it was, well, like in the opinion they called it the duck test. It walked like a duck, it quacked like a duck. It is a duck, and all means it was a regular town. It had police forces, it had sewage. Just because it was owned by one person didn't mean that the protections of the Constitution stopped at that place. And for the fact that the access to the town, like you can drive off the highway, one of the exits led you right into the town. So the court said it was indistinguishable from any town. So your constitutional rights shouldn't end because of this. But this was the first time the Supreme Court had made that distinction to say that yes, a private property could be deemed for purposes of Constitution could be restrained. Yeah. So that's what PragerU was hoping for. But the court said that YouTube is not similar to a company town, and that PragerU's arguments were simply a little bit silly. So because YouTube is not a government entity, then the First Amendment doesn't apply, and the Latham Act doesn't apply. And PragerU lost. And for the appeal, they just appealed it to the Ninth Circuit. The Ninth Circuit denied their appeal, but now made it binding precedent, and that's kind of where we're at. But that's again in a nutshell. It's
interesting, and that is they appealed only on the question of whether or not it could be deemed to be the equivalent of a government corporation.
Yes, government entity.
So, because I remember back in the day, back when I first reviewed it, there was the question also as to whether or not they were going to argue the de facto monopoly, as to whether or not, as a result of the de facto monopoly, it ought to be treated as a government a government entity for application of First Amendment rights.
But that would only work from my understanding. Again, it is limited, but there's only two ways that'll work. If you're a de facto monopoly, but the good and service, like for instance, if we're talking about electricity, if you're a de facto monopoly in an area, then there's some of the constitutional protections that you have to abide by. Like for instance, anti-discrimination. You can't say I'm not going to give electricity to this certain group of people because of their skin color, for instance. So that type of monopolistic, and usually it's heavily regulated, especially in the state and even on the federal level, nuclear power and stuff like that, or regulated that way. But then you have, these kind of monopolies like AT&T, for instance, was a monopoly in the phone industry before we knew that phones were going to be so vital, or Microsoft. And in that sense, then you're talking about antitrust laws, because antitrust laws, you're talking about something that affects the market versus something that people need to survive. Does that make sense?
Yeah. No, that's it. But that's it. So, but did they address the UNRU provisions of governing political affiliation? Because the UNRU Act in California set out certain restrictions on discrimination, but didn't specifically mention political affiliation.
But I thought the UNRU Act was just California. This was the Ninth Circuit. I thought they were talking about what happened? First Amendment violations for Prager.
See, this is the last time I checked into the file, which was they had filed in federal.
I think you're right, though.
They had filed in federal. They were referred back to state. They were invoking the UNRU. Okay, this might require follow-up because I actually.
Oh no, I know what happened. They had sued in federal court based on the First Amendment and based on the Latham Act, and then through supplemental jurisdiction, they then attached their state claims to it and said, okay, we'll deal with all of these claims in federal court.
Yeah.
But then when the federal court dismissed the federal claims because YouTube wasn't found to be a state actor, that still left their state claims. So by dismissing it, the court didn't have jurisdiction anymore and sent those other claims back to the state court. So I'm not sure how the state court disposed of those claims, but the other claims were then appealed up to the Ninth Circuit. The original claims for the First Amendment.
Okay, very cool. By the way, so Mike Lombardo says this is going back to the Vic. The judge asked Vic's team to prove the case at this TPA stage. Obviously, this is not the point of the hearing. I mean, fair enough observation is arguing the merits of the case on a dismissal stage. Hold on one second. I missed one here. Hold on. But that's it, Nate. So we're going to have to see what the deal is on the state claims, because they still might have their UNRU claims on the state level. And so,
but just to let everybody.
Oh yeah, go ahead. Sorry.
But just to let everybody know that there's actually a test for state action. I think it might have changed in the Supreme Court tinkered with a little bit, but the one I remember is the Edmondson Luger test. And if you apply the Edmondson Luger test to a certain situation, that's how the court would determine if a private company can, in all fairness, be called a state actor or not, and whether the Constitution will apply to their action.
The company town cases were largely like logging towns or mining towns, which were set up in the middle of nowhere and to bring in people for the logging and mining. And because it's in the middle of nowhere, the company had to build places for them to live and places for them to worship, and sometimes issue them company money, because some of these cases are pretty old. And before too long, they have their own security forces and their own fire department and so own everything, because we're starting to talk about a lot of people. So it looks and shapes like a town, but it's all owned by the company. But the problem is it's so all-encompassing that at that point, it's like, what's the difference between this and government action? Is YouTube that? No, because YouTube is big, but they're not the only game in town. They're a big game in town, but they're not the all-encompassing world. There was a case in the late 90s, I want to say, against AOL, when, if we remember the late 90s, when AOL owned the internet, as it were, and they said no, even then it wasn't, because there were competitors to AOL, and now AOL doesn't really exist so much anymore. So we can see how fleeting that could be. So YouTube may itself fall, as so many companies have at one point, and to say it will be for all time is a little bit near here nor there. So
no, totally understand. Yeah. And okay, Joe's Mead says there needs to be a legislative solution to the PragerU YouTube situation. Prager's mistake was he tried to sue with the current state of the law. Well, so this was something that Robert Barnes said in a couple of live streams. He said, win or lose on the merits. If you win, you win. If you lose, you might win because you might stimulate some sort of government action or legislative action, and that's probably what it's going to take at this point to ensure that there's equal treatment on the platform.
But you know what? But one of the things I did find interesting about PragerU's argument was about how because they were being discriminated against, more or less, because they were conservative. But then how the other side pointed out that they had another lawsuit, the LGBT coming saying the exact opposite thing. So who's right? They both can't be right.
Like I might have not harped on the the right versus the left ideological distinction, but rather just any form of ideological discrimination on a platform that's supposed to be open to the public. But then the ultimate argument is the accessibility is not the same thing as promotability on the platform. And then you're going to have the argument, yeah, we'll give you the platform. We're just not going to promote you the same way we promote other stuff, because we have our own business concerns, which if you don't like the platform, then go to BitChute and go to the other platforms where you might have, you might like it better, except you might be promoted on the front page, but nobody's watching type thing. It is a delicate thing. I just think there is ideological, I won't call it discrimination, but ideological decision making going on. There's no question. But whether or not it's right versus left, obviously not, because the attorneys representing PragerU were the same ones representing the LGBTQ who were suing YouTube for the exact same ideological discrimination. Sorry, go ahead. Any chance of higher appeal? Jorge Fabrizio says Supreme Court.
Supreme Court.
No.
But I think this is a two-part question. Number one, if we're talking about just access to the platform and uploading videos, PlagerU has the ability to do that. If we're talking about making money and promotion, I think that's another version. And I think that piece of it, even though these, because the big argument is about being demonetized, and if that's the argument, then that's really about advertisers. This is advertisers saying, I don't want my stuff on this type of stuff. And at that point in time, you can't really blame YouTube because they still want the advertising revenue. If advertisers wanted their stuff on PragerU stuff or wanted their stuff on the LGBT stuff, we wouldn't have a problem. But that's just what it is. That's the reality. I think people just don't want to say.
Well, so my personal belief is I don't believe that argument from YouTube. I think that advertisers want to put their money wherever the eyeballs are, whether or not it's on PragerU or LGBTQ stuff. I don't believe that. I think it is ideological at the YouTube level, or at least in theory. But that's something we'll never know really until there's regulation that says you just can't do it. Period. And have the auction for advertising stuff and see where it goes. Excuse me. Real Bambuga says, Nate Borody, would Marsh vs. Alabama have applied similarly in Antelope, Oregon, the Rajneesh cult town? I don't know what that is.
I'm assuming that this is just like a cult where they run a complete town. So the cult is essentially the private corporation. So potentially, yeah, I mean, it would be the same kind of analysis. So yeah, I depend. Yeah, potentially. It would also depend to the degree to which the public can access it, because in the company town cases, the public was able to get to the streets. They weren't completely walled off and guards at the place, so people could. I don't know if they were able to drive at this point in history, but for the sake of it, they were able to drive in and go into it so that they were open to the public. So if you have a completely encompassed cult compound, then you're probably not in a company town new.
Yeah, that was one of the big issues with Marsh, is that people could just drive off the highway and drive into the town. There was no barriers and stuff. Yeah.
Interesting. Okay, we got Mike Lombardo says, I'm not saying I don't agree with Uncivil. I just think the judge at the hearing was asking Vic to have to prove a much higher standard than required. Well, you'll see that's what the appeal is for. But the problem is the level of deference. I'm assuming it's the same thing in the States as it is in Canada. The level of deference that you have to show to the level of deference that the Court of Appeal is going to show to the trial judge or the one who rendered the original decision.
And I think that's ultimately the problem for Rick on appeal. It's even if you think the judge made the wrong judgment call, which I think is a valid view, the next question you have to ask, is it an abuse of discretion, clear error kind of situation? Now, I know the Vic people wish it was abuse of discretion, clear error, but at least in my humble opinion, based on what I've seen so far, I don't think we're there. Now, does that mean that I don't think? Does that mean it's not possible? No, I'm not saying if they reverse, it would completely shock me. I'm just trying to analyze the case as I've seen, trying to analyze the laws I've seen, and trying to make a reasonable prediction. Based on what I've seen, I don't think Vic can get where he needs to be. It's just my view on. But did the judge mess up? Maybe. Did he mess up to the degree Vic can win? Not in my view.
Well, not only can Vic win, but can Vic win on overturning the decision so that it can go back for a trial on the merits?
Yeah, no, I don't really see that happening, and that's I think because I don't think it was put in a good posture by Vic's team. It just didn't feel like it was put in best position to win.
Well, two things. Number one, were the arguments bad, or was there at least evidence to show that he may have been right? Because sometimes if it depended on the standard of the appellate division, if the facts are in and it's supposed to go the other way, sometimes they'll just go the other way because it'll still be based on the law, but the facts will be clear.
There were definitely I think there was procedural mistakes, in my view, by Vic's lawyers. They made the improper complaint. It was improperly notarized. They struck the complaint without a clear knowing that they'd be able to respond. They tried to file within a certain time period where the judge appeared to have discretion under some interpretation of the rules. The evidence, therefore, wasn't brought in because it wasn't part of the record. I didn't feel it was well pleaded. I just felt there was some tactical. I thought there's some tactical procedural missteps where things could have been done in a different way, where evidence that could have been brought in the record, as far as I understand, wasn't. because of improper notarizations. And I feel the judge, judges have been known to like hold things like you mistakenly notarizing something when you can't, and then like penalize you endlessly for it forever because they now doubt your trustworthiness. So it wouldn't surprise me. It wouldn't surprise me if the judge looked at that and said, I'm now going to basically take that, and now you're in my penalty box, and anytime I have discretion, I'm going to rule against you. And it's not even a conscious thing. It's just like all humans do. If you don't trust someone, you don't trust someone. So I just feel like the judge basically used any discretion they had and be like, no.
I'm screenshotting.
One thing.
I think apparently we need to watch this movie, Wild Wild Country. Real Lambuga, thank you.
Sure.
But I'm watching this ASAP.
One thing, I because we've been talking about it being on the record, and just so everybody knows the significance of that, on appeal, whatever's not in the record, it's like it didn't happen. So, so that's why it's important. So when Uncivil Law is saying they had evidence that they didn't get on the record, that on appeal, that evidence it's like it doesn't exist. So that's why if you're as an attorney, if you miss two things, if you don't make the objection, number one, you have to make the objection, because then if you don't make the objection, it's a whole another big problem.
There was I noticed this on Vic's stream where they were arguing about it, and I couldn't remember the precise context, but an objection that wasn't made, and Vic was unsure like which way it would go in terms of who that would be ruled in favor of, in terms of whether something was or was not on the record, because there was an ambiguity as to like, well, someone should have objected and the other side should have said this, and no one like perfected it. But my view is it's not on the record. That's my conclusion. I understand there was an argument about this issue, and Vic was Rakita was looking at it both ways and making the argument about how it could go for either way. My view is it's not on the record, but we'll see if the appeal court may.
So
getting involved in this at this point would be getting involved with a well of knowledge that most people don't have.
This is why you didn't want to cover this issue, Viva, because like I'm reasonably well informed, but not nearly well as informed as Rakita and many of the people.
40,000 people who.
So I was like, I've read some stuff, and this is why I say, and they're like, they're raining down fire upon me because I haven't come out with the conclusion they want. I'm like, look, guys, I'm just a simple country lawyer. I've looked at this as a conclusion I've come to. It doesn't mean I'm God. I'm just giving you my opinion.
But look at many issues that you've just brought up. Number one, was it actually even objected to properly? Because that's an issue, Then that turns into the issue of whether it can even be appealed properly, because there's no facts. If the facts aren't on the record, then it can't be appealed. So just those two issues are the bombs themselves, and then you're saying it's even more. So they're really, really deep.
There were lots of depositions in the file. That much I know for certain. Okay, let's get to these before we forget. Tater Raider says YouTube tech chans are unable to name COVID-19 without demonetization, despite it affecting the supply chain. YouTube can do that, but does that make sense to do? No, it makes no sense.
No.
Makes no sense. And there's no one's going to say it makes sense. And it makes no sense. It's not like that is demonetizable on its face. It makes no sense. 64 pink 256. I don't even want to ask, but 64 and 256 are related. Times 4. 4 into 256. Okay, whatever. John Ward was Dunker. But you guys are still awesome. Okay. I don't do it. I'm not sure what that means. Sounds good. It ended well. Okay. And I didn't miss anything else after that. Good. Yeah. It makes the automatic demonetization, if you say certain words, makes no sense, but it's the scale that YouTube works on. Like, you're not going to get individual manual review for a 3-hour live stream. So they can make sure that COVID, whatever, was not used. I don't even know how that works. It makes no sense.
The super chat.
Tony Niev says, time for a barn burner. Have you all heard of any anti-death penalty cases arguing that death penalty is unconstitutional via removing right to life?
No, and
we've been through this before.
It's kind of a non-starter, because the Constitution says a person can't be deprived of life, liberty, or property except with due process of law, which implies that if you've gotten due process of law, you can be deprived of life, liberty, or property. We deprive people of property with due process of law all the time. In civil lawsuits, we deprive people of liberty all the time. In criminal cases, that's putting them in jail or prison. So can you deprive someone of life with due process of law? On substantive due process, yes. Then you get into the procedural due process issues. But I don't think it's a starter, because the Constitution says you can't be deprived of life without due process. Therefore, the Constitution implies that with due process, you can be deprived of life. Therefore, it doesn't make logical sense to my mind.
And I imagine that the term life, when used in the context of the drafting of that, meant death penalty. It was not like a question of life in the metaphoric sense, like we can take your life by putting you in jail. It was, we can take your life by cutting your head off.
Yeah.
But the Supreme Court has been back and forth on this, though, because at one point they had the opposite feeling, right? That the death penalty was unconstitutional. So
they said that really at one point too. Yes.
Yeah, so it seems like it seems like we're all over the place.
That would be the argument that I would raise. Now, this is coming from someone who, at one point, I think I was supported the death penalty, and now I think I don't necessarily support the death penalty just as a concept. But I would argue that when we said we're going to take life, liberty, and happiness, or life, whatever, property, and we have physical life. We just meant like, if we put you in jail for the rest of your life, that's meant by taking your life.
I agree with Blackleaf, though. I mean,
I have an ethics perspective on this, which may be unique, and I'm happy to be challenged on it. But if we presume the guilty case, so we can just take the innocence possibility, presume the guilty case, and our decision is between life in prison or the death penalty. It's like, well, the end result is the person is going to die in prison either way, right? So we're only deciding between whether or not we're going to Reaper and fate will do it for us. And I argue it's actually a little bit cowardly and divorcing ourselves of responsibility. If we're that committed, if we really believe that that's a just outcome, then shouldn't we have the conviction of our own conscience to actually do it ourselves rather than leave it to the trial of fate? It's like, in the case of the actual guilty person, I don't really see how life in prison is the more ethical solution. It's like, if we really believe it, we should have the courage to do it.
Well,
one response to that is that I would agree, but I would think you need to change the standard then. The standard shouldn't be beyond a reasonable doubt for the death penalty. It should be beyond doubt. And what I mean by that is that if you have somebody who's, sat there on a videotape killing someone, and you can prove it, beyond doubt, that, because again, beyond a reasonable doubt, where it could be, but I think the only way you could do that, because the death penalty is something you can't appeal. It's over. It's done for. So I would only be comfortable if you had that type of certitude in the fact that this actually occurred, then just beyond a reasonable doubt.
Okay, and before we get there, let me just do 3 super chats. Mike Lombardo, the judge did not rule one way or another on the second petition. He did not rule on several things. That is part of the appeal, obviously. This is a level of detail that we are not qualified. That at least I'm not qualified to get into for that particular case.
That was Nick Rakita's argument. They didn't rule for it either way, and so there's an open issue.
We got Blackleaf just got here. If you're around San Antonio, I'll buy you a beer from Ghost of Recon.
Noted.
Thank you very much.
I could travel there.
Everyone knows Uncivil Law and Nate Brody's channel. We got life in prison is cooler than the death penalty, in my opinion. Okay. Yeah. I'm gonna tell Blackleaf why he's wrong.
Please inform me.
Because following that rationale, someone who is, let's just say, terminally ill in a hospital is going to be kept in a hospital until they die, so you may as well kill them when they get there, if we're following that rationale of doomed for when they enter the institution. That would be the one. That would be the one.
But we're not judging they should die. That's the difference in the hospital case. No one's making the judgment that, like, in principle, this person is worthy of death. Like, whether or not we should offer them death because it's more merciful is a whole nother problem. But no one's saying that this person should die.
Well, you're saying you're saying the argument
it's morally good, or more. How do you phrase this in a way that I'm having trouble phrasing it? You understand what I mean, though?
Yeah, I think we understand what
you're phrasing it. We are morally justified to kill this person because it's either that or we keep them in jail for the rest of their lives for the crime they've been convicted of. And I would only argue that there's a ideological, I don't want to say biblical, but there's an ideological distinction between imprisoning someone or even housing someone until they die versus taking their life. And I don't know who. This is the question: is at a certain point in my life, I was like, I don't know who gets to decide to actually take the life. as opposed to punishing and let the life end when it ends. That would be setting aside the whole false accusation, the false guilt. Let's just say, yeah, we have the video. Even still, the act of wanting to kill is not an act of punishment. It's not. It's less of an issue of punishment versus an issue of retribution, which I think is not reciprocity. Yeah, but reciprocity is rarely if the victim wanted to do it, I would say the victim would be the only person who's legally entitled to do it. And
reciprocity is in general an accepted theory of punishment, along with deterrence and isolation and all the rest of it. So the idea that we should balance the scales is a valid theory.
Well, but it's the we who gets to balance the scales. That's the issue. Like I would agree. I would allow the victim, to the extent that they're still alive. No, I would allow the victim to do it. Period. And if the victim is no longer alive, then who gets the reciprocity? The state? I fundamentally take issue with anybody taking another person's life, even when it's merited. Keep him in jail. From what I understand, it's cheaper anyhow than the execution and the delays and the appeals and the process. Keep him in jail.
The solution to that is to take away all that nasty due process and just make it a lot faster. Then it'll be cheaper.
So hold on. Actually, now the Bambunga asked the question I was going to say. Someone said it's crueler to keep them in prison than it is to kill them. So let the inmate end their own life if that's the argument. If they say, would you rather spend the rest of your life in jail or would you rather euthanize yourself?
Yeah, I don't know, man. If I had to pick, man, I don't know, man. The death penalty might be preferable.
Well, what do you guys think about this? Because this leads us to, I think, what they call the 4 theories of punishment. The first is and this is what in federal courts and even most state courts, these are the 4 theories of punishment where penalties to criminal violations should speak to each one of these 4. You want to have a really great sentence. It would speak to all 4, but sometimes because you got to treat them like factors. The first is deterrence, and you want to deter other people from doing the particular crime. Then incapacitation, removing the person from society for a certain amount of time. Rehabilitation, you want to see if you can reintroduce this person to society. And then retribution, you want the person to pay a penalty for their wrong. So those are the 4 theories of punishment that you want to accomplish. And from what I'm reading, it seems like the death penalty kind of takes away. It doesn't give you all 4 theories of punishment. It only really gives you one, retribution, kind of ignoring the other 3.
Well, I mean, if you think
except for deterrence.
Yeah, well, deterrence, but isolation is neutral either way because they're locked up until they die, so it's kind of a neutral factor. Although actually, it's not. It's actually slightly better in the case of the death penalty, because even in prison, the person poses a threat to guards and fellow prisoners. It's not like murders haven't ever been known to happen in prison before, right? So you can argue that the isolation effect is better in the death penalty. The reciprocity element is better.
The isolation can't get much worse than the death penalty.
Yeah, so it's like when you look at the factors, it just seems to me like I don't know. Rehabilitation is a non-starter because you're not getting out of jail either way. So that's
but deterrence has not even been shown as to be a true factor. That's why a lot of the states got rid of the death penalty, because it just wasn't deterring anything. And then you're talking about there's no rehabilitation.
But
it's really only retribution.
I don't think the answer is rehabilitation or deterrence versus the death penalty in the abstract. We need to look to the next closest alternative. So there would be the question of deterrence of life imprisonment versus death penalty. And if they're equally deterrent, then it's a neutral factor. Because the only question we're asking is, should we abolish the death penalty, then therefore presumably give life imprisonment? So we have to look at the deterrence factor as it exists between life imprisonment and the death penalty. So if there is no deterrence difference, then there's no deterrence difference. It's a neutral factor.
Zex, and I thought there was a fly on my screen for a second, says offender will exhaust the appeals process, whether life in prison or death penalty. So the cost is the same. Okay, so that's interesting because that's a very logical observation. It's a question of whether or not it's true in fact as to which one costs more. Because I do know this. The standard argument is that the death penalty costs more than life in prison because of whatever, and I don't know if it's true. I just know I've heard the argument. Thank you very much, by the way. Andrew King says both the death penalty and life imprisonment are cruel and unusual. Now what?
Yeah, I mean that's exactly one of the problems. So I don't think it's a cruel and unusual view. I mean, you could talk if we want to talk about specific methods of execution as cruel and unusual. We can have that discussion. That's separate. But we are presuming a non-cruel and unusual method of execution for the purposes of this argument, so that we can compare them in a neutral way. But yeah, I don't think it seems odd to me. It just seems odd to me to say that the death penalty is cruel and unusual and life imprisonment is not cruel and unusual, because you die at the end either way, and we've determined that you're worthy of this. That's the reason we're isolating you versus the hospital case. You're worthy of this consequence, and to argue that you spending an additional 30 years alive is, I don't really see the moral value in it personally.
The problem with this for me is that you're arguing an ends test. They both die anyway. But I think the argument really is about the means, right? It's in one instance you're saying, in one instance we're talking about killing someone, and in the other instance it's a 30, maybe 60 years of life. So I'm not sure. Could that person add any value, or is there no value in this person's life? Or have we judged this person to be valueless? So at the end of the day, yes, both these people will die, but I don't know if you what have you accomplished? Is there anything to accomplish? Or are we just giving up on this person? And I think at the point that's what we're saying. By putting him in jail, there's nothing more that no other value this person can give society.
No, France had a really uncruel method of execution. Do I ask? I'm not sure if I want to ask what
that'd be the guillotine.
Well, the
guillotine.
Which they were using until the 1970s, right? So good for them.
Well, it can't get less. It can't get more. It can't get more instantaneous than that. But no, I'm not with Nate. This my view is that we're not in the position to take the life. We can do what is necessary to prevent additional risk, to punish, but we're not in that position to actually remove the life. It was not ours to take in the first place. And I also do think that if they can do to the extent they do no good, that's one thing. But there have been lots of people on death row who have done very good things, and to eliminate that possibility is of no value to anybody. And then the other reality is, setting aside the cost, the reality is that there are processes to the appeals process, and by the time you end up executing the person, sometimes they're no longer the same person that committed the crime, and you're not even executing the same person, and therefore you're not serving any of the deterrent. You're not serving any of the punitive functions. It's just taking somebody else's life, when there are other more humane ways of exacting the punishment for the crime that they committed however many years ago. But that's it. I mean, it's philosophical. I understand Uncivil. I mean, I understand, Kurt, exactly what you're saying, and it's not that I think it's wrong. It's just that it is a perspective difference as to whether or not it's what you want to tolerate in the society in which you want to live. Ideally, I say we shouldn't kill people, even if they're the worst people on earth. Keep them in jail, isolation, and it might not be any better, but at the very least, you're not doing that for which they're being punished. In a sense, it's not because it's justified murder that it's murder nonetheless, especially when it's unprovoked in the execution sense.
What does the philosopher say? I forget. I'm not sure if it's the Kant, but society must be judged by the way it treats its worst and most vile. That's the way your society is judged. If it treats them bad, then
I believe Kant also called the death penalty a categorical imperative. So there
was
that.
Yeah.
Well, no, it might have fit into the. I don't know if that means it was a categorical imperative not to do because you just whatever. But no, they also say that decapitation isn't instantaneous as they claim. It's been proven that the head is still alive for several minutes after separation.
Ooh.
Oh well,
yes,
I'm not.
The eyes blink and the mouth moves, but the significance of aliveness is questionable. But if it were up to me, I would go with nitrogen asphyxiation, because that is non-cruel. You just become very tired and fall asleep. And it's foolproof, and you can safely vent the nitrogen atmosphere when you're done, because the atmosphere is 78% nitrogen. So nitrogen asphyxiation is my vote if it ever comes up.
Well, look, all that I know is I've been under general anesthetics multiple times. I couldn't imagine. I mean, I don't think I would have not noticed not waking up. I mean, it couldn't be any more peaceful than that. But No, it is a purely philosophical question as to whether or not we think we're entitled as humans to take the life of another human, even when it's warranted, in the absence of an immediate threat of life or death. That's the problem with the death penalties. Oftentimes it happens so much later, it's just totally unrelated to the actual crime. And now it's just a pure question of we're getting back at you, and we think we have the power to do it. Okay, and it's 2 hours in, so I think we can hold on. Real Bambunga says, hold on before we do this. I think we should end this because it is late. Okay, we got the decapitation of this video, so we're not the words that have been used here. And I haven't even reading. I've been reading the comments in the comment section, but some of them I can't even address because they are just too. In one day in a live meetup, Bambunga says, okay, let's lighten the mood here. Who here doesn't like paying taxes? Speaking of a life of pain to the government. Okay, shall we? We'll wind this up and we'll say thank you to everybody. There's nothing else. I think. If anybody wants to get a pinned comment, time-stamping this, I will pin it and I will send you a shirt. I promise you. Anybody who does it, the first person who does it, there might be more than one.
Can I have a shirt?
We lost Viva.
We lost Viva. Well, that was good. Well, we promised the shirt and then we lost Viva. Okay,
that's it. We promised the shirt. That's
what do you want to talk about, Nate?
I don't know. We're taking over Viva's channel. We're taking over. Oh,
I don't even know what just happened, but at least I came back very quickly. I will send the two of you gentlemen shirts anyhow. But anybody who timestamps this, pin the comment, DM me you're the first person to do it. I'll send you a shirt. Okay, good. Well, that was close to having the worst ending ever to a live stream. Everyone, thank you very much. I think we got everyone. Thank you for the super chats. Thank you for the comments. Nate Borady on YouTube, Kurt Uncivil Law. Let's do this as often as you guys are game for it, and we'll do it on one of your channels next time, and
yes.
we'll rotate around.
If you like this content, please go to my channel and subscribe to me. It would be nice. Thank you.
Uncivil Law. It's got a little blue icon. Nate Borady has got the avatar, which is a fantastic avatar. Keep comment vlog on, and that's it. Let's do this. Next time we'll do it. Maybe next week. I will end the broadcast, guys. Thank you very much. It was phenomenal. Stick around. We'll talk afterwards just to tie up the loose ends. Everybody, thank you very much. And
now you know your vlog.
Now you know your vlog.
Now you know your vlog.